Hello there, and welcome to this session on data protection and COVID-19, a webinar that was delivered to the Essex Chambers of Commerce in July 2020. My name is Scott Salmons, and I am the primary consultant at an organisation called Lighthouse IG. I've worked in information governance for a number of years now, and I'm certified across a number of areas including data protection, information and records management, freedom of information, and cyber security. One of the things that Lighthouse IG does is support organisations with workshops, reviews on your handling of personal data, and provide you with training so that you can upskill your staff on various different aspects of looking after customer data. So what we're going to look at in this session is everything to do with the track and trace programme and simple steps that businesses can take to comply with or work with the track and trace programme if they so choose to. Now, first of all, this particular webinar will focus on customer data, not employee data. There'll be a separate webinar for that. This is just customer data. Let's start with what is expected. So, the opening up of the economy following the COVID-19 outbreak is being supported by the NHS track and trace system, or is also being supported by the test and trace, but for the majority of you, track and trace is one option for you. Now, it's worth noting that track and trace is not mandatory under English law. Therefore, you cannot state to your customers that they must provide this data or be refused service on the back of it. Instead, it should be based on your health and safety risk assessment, and we'll come back to that a little bit earlier on. If you do choose to collect data, there are various different ways of doing it, and again, most of it should be based on your physical setup, how customers will be coming in and out of your building, and your existing structures and processes if you can. So what we're going to do is say, right, the requirements for handling personal data for the track and trace programme, they're bound by 7 basic rules. Principle number 1, that your use of it should be fair, lawful and transparent. 2, that it should be a limited purpose and not reused for a different reason, and we'll talk about a little bit more about that in a moment. That you only use what you need. Number 3, that you keep it accurate. Number 4, that you only keep it as long as you need it. Number 5, number 6, you keep it secure. And number 7, you use it in an accountable manner. Now, when we talk about fairness, it then becomes a question of, well, is it fair to keep lists of visitors to, say, your pub or restaurant or other? Given everything that's going on with the COVID-19 programme, one could make an argument that it probably is fair, providing that you provide certain other bits and pieces of there if someone so chooses to do it. Enforcing that on them, given the fact that it's not lawful in the UK, probably wouldn't work. So if we are going to use customer data for this particular purpose, then we need to justify it via a condition in Article 6 in the GDPr, or if we're using special category data, so medical information, a condition from Article 9. Now, we're going to be using that personal data for one of 2 reasons. Keeping a record of your visit is the main one, and then sharing that information with the NHS track and trace programme should you be contacted or have a justifiable reason for doing so. At the moment, but you can't force it based on a legal obligation, so you cannot say that the track and trace programme is a legal requirement, therefore you must give it to me. Therefore, the only things you can use are the data subject's consent, so the customer's consent, or your own legitimate interest as a data controller. And this is where it very much does depend on your own risk assessment that you've completed as part of your health and safety programme. So if your particular business, your particular area that you're functioning is high risk, some of your other controls mean that it's difficult to socially distance or difficult to put in other hygiene controls, various other bits and pieces, where relying on a reactive control like track and trace may be your only option, then you could make a strong argument that there is a legitimate purpose for collecting that data, that it may well be necessary for you to do in order for you to reopen, and that on the balance, providing you put some of the other things in place that we're going to talk about now, that it is a legitimate thing to do. But again, you've got to determine what is your legitimate interest based on that risk assessment. If you've got plenty of other things in place, you do social distancing, you've got screens and all the other range of PPE related equipment, then track and trace won't serve much use to you. it can legitimately be an optional thing should someone want to take part in it. Whereas if it is the only thing that you've got realistically to implement, then you're going to rely on it more and more. As part of that, you need to make sure that you're being transparent with those that are using your service. So this is where you would say, okay, this is what I'm using it for. So when someone comes in, for example, into your pub, into your restaurant, whatever, you would outline to them what you're using personal data for, why, how long you're going to keep them, those sorts of things. And you can do it in various different ways. You can do it via a paper form, a sign, verbally, electronically, if you've got an electronic system that you're using to take the booking, whatever it might be. Work out what your channels are for getting customers in, be that booking online or whatever it might be, and make sure that you give an appropriate notice accordingly. There's loads of details and resources online for how to create one, and there are some example ones knocking around as well, so do have a look out for some of those. Another thing to be aware of, which comes under Principle 2, is now that you're being required to keep a list of customers and where they are and where they're not, or sorry, while you're choosing to collect a list of customers and why they're there and why they're not, that means you've now got a list of everyone that's come into your building or everyone that's come into your premises that you've never had before. The temptation to use that information for marketing purposes or for a staff member to use it to contact a customer that they liked, which has happened already, is quite strong. And both those uses, if you've not told someone that's what it's going to be used for and haven't got a legitimate reason for doing so, then again it could land you in trouble. Therefore, you need to put things in place to stop people from accessing that data inappropriately. Lock it away at the end of every night. Delete it after the retention period that we're going to talk about in a moment. Train staff to know that accessing that list to go after that pretty person that they saw come into the bar may well have criminal ramifications. Therefore, just don't do it. Principle number 3, don't be creepy, only keep what you need. So for the purposes of track and trace or keeping a record of who has come into your premises, you need their name, their contact detail, email or phone. If they don't want to give you either, they want to give you their address, fine, and the date and time of their visit. That's it. What you can do, and what many organisations are doing, is recording. So if there's a group of people, they'll record the lead booker, and they'll nominate a person to be the contact. That would work as well. Principle number 4, keep it accurate and up to date. Because this is a legal requirement to do it, you can't demand verification of the data that they're providing to you. So for example, you can't ask for proof of ID or anything like that. So if they want to call themselves Bob Marley, they are well within their rights to do so. You can say to them, you can ask them, is that right? However, if they want to do it, so be it. At the moment, the recommended retention period for principle number 5, only keeping it for as long as necessary, is 21 days from the date of their visit. So if I visit your premises today, in 21 days' time, starting tomorrow, you will delete that data. And deletion of that data could be done via a number of means depending on how you're storing it. So for paper, make sure you securely destroy it by a good quality shredder, ideally one of the cross-cutting shredders. If it's electronic, make sure that you delete it thoroughly. It's not just deleted from your desktop and it sits in the recycling bin or anything like that. Make sure that once it's gone, it's gone. Principle number 6 is then making sure that information is kept secure. And this is where you need to put things in place to stop that information from being inadvertently disclosed or accessed by anyone that shouldn't access to it. So for example, make sure you keep paper records locked away or securely destroyed when no longer needed. Make sure that your website or your booking application is up to date and on a reliable platform. Reset and change your passwords to more secure standard. If you've been using password 1 up until now, now is the time to try and change it. Principle number 7 is then being accountable. Organisations should be able to demonstrate this is what you're doing. So if you are going to keep such a register, have some rules in place. Demonstrate that you've told staff what those rules are, they've had training on it, and that if you are using an outsourced third-party application, that you put a contract in place, your employment contracts are robust and up to date, those sorts of things. Be accountable for this data that's now going to be within your care. If you've not already registered with the ICO, then now is a good time to do so. As an employer, you should already be registered with the ICO. However, If you've not done it for one reason or the other, go onto their website, ico.org.uk/for organisations/data protection fee, and you can find details of how to register and how much it will cost you. If it's just for employees and you've only got a handful, then it's probably going to cost you something like £35, £40. Whereas the more larger and more complex you are, the more the price goes up. Another thing to consider around security is then working with the NHS track and trace system itself. There have already been a number of scams and people pretending to be part of the track and trace system when they're not. So make sure that any requests that you get from the system are verified, that they ring you from their official number, and don't just give the data out to anyone that calls up claiming to be from track and trace. There's loads of details online on their website about how it works, who they'll call you, what the process will be. So if you're unsure, do feel free to challenge, and again, they will respect that. Another part of handling this information is that you need to honour and respect people's rights over that data. So they have the right to be transparent, and this is where you'll tell them this is what you're doing and this is how you're doing it, but you'll also give them access to it. So if they want to see what's on their register, it's highly unlikely that they will, but should they need to, don't just give it out to anyone that asks for it. Make sure that you've got the right person. So if they're able to confirm that they are this person of this email address, and that they confirm their date and time. If you want to say, okay, I'm just going to verify who you are by ringing the number. If you answer the phone, yeah, it's very clearly you. Done. Simple. That way then if you want to go, yeah, I've got you down for here, this time, this date. Lovely. Otherwise, you can see a scenario whereby someone will try and stalk someone by confirming where they were at any given time, and it's not appropriate that we give that out to that information to a third party. People also have the right to rectification. So if someone says, actually I gave you the wrong mobile number, or you've got an error there, or can I just check the mobile number that I gave you and it's wrong, verify who they are and then just make the correction. Obviously, if they're saying that they were never in your pub or they were never in your organisation when they were, and you know that they were, then again you might want to look to say, no, I'm not going to honour that because I'm keeping this for these reasons. However, if it's just a spelling error, a thingy error, then look to change it. Same thing for erasure. If it's errors, it should be deleted. Other than that, entries should be retained only for 21 days. So if someone writes in saying, I want you to delete it, saying, well, it's in my legitimate interest to keep it for 21 days, therefore I believe that to be stronger. Right of restriction, again, process to mark data not to be used for anything other than track and trace. It could be that they say that I'm happy for you to contact me if someone else has been in the building at this particular time, but I don't want it shared with track and trace. That's a legitimate thing for someone to do as well. It's highly unlikely that they would, but be aware of that. Make sure staff are trained on that. I wouldn't worry about the right of data portability because it doesn't apply. People could object to what you're doing, and again, this is where you'd need to make sure that your risk assessment, your health and safety point of view is robust. Otherwise, if you're just doing it because you think it's a good idea, then they are well within their rights to go, well, no, I don't want to give that information, or someone gave this information to you, I want you to delete it. You also don't have to worry about automated decision making and profiling because you're not doing any of that. But make sure that if someone does complain, that you give them details about how they can speak to the bar manager, restaurant manager, whatever it might be, should they have any concerns or queries regarding what you're doing with the system. So remember that your legal basis for using this information is your own legitimate interests, but that's very much based on your health and safety risk assessments. So if you've not done one already, do one. I highly recommend the guidance and templates that's on the Health and Safety Executives website. So if you've not seen them already, go and have a look and see what you need to do for your organisation. Make sure your customers are given a decent privacy notice that explains what you're doing. People can do this either via paper, electronically, via an app, various different means. Make sure if you are looking after this data that you keep it secure and only use it for the reasons that you're using it for. Only keep it for 21 days. Make sure access is restricted and handled correctly. Make sure it's securely destroyed. And again, you can't get proof of ID because it's not a mandatory requirement. Do keep an eye out on the Essex Chambers website for more resources and details. There's also some more details on the ICO's website, ico.org.uk, and as I said to you before, the risk assessments on the Health and Safety Executives website that's available online. Otherwise, keep an eye out on Lighthouse IG for further details of further webinars and other related things to support you through the new normal. Thank you very much.